Have you ever sat down and read the Constitution? Probably not. At least probably not willingly, or at least not when a teacher didn't assign it to you. And what you did read was probably, the Bill of Rights, the first 10 amendments, maybe Articles 1 and 2 about Congress and the president, but even that's a little weedsy. Maybe you learned about the 14th Amendment and the Emancipation Proclamation, which isn't an amendment but goes hand in hand. Maybe you learned about prohibition, the 18th Amendment that banned alcohol, maybe the 21st Amendment that repealed that one, the only amendment to repeal another amendment. And maybe you learned about the very important Middle Amendment in there, the 19th, that gave women the right to vote. Maybe all this is new to you, maybe it's brushing off some cobwebs, but most of the time the Constitution feels stale. It feels like it wasn't written really for us, and certainly wasn't written by us, the people who are alive and living today. So much of what I do on this show, and certainly so much of what I do on Things You Forgot from Civics class, is try to disabuse you of that idea, to show you that the Constitution and what's in our laws and our foundings of the country, both at the founding but also at different points along the way, those are living, breathing things, and that they're roadmaps and ways for us to preserve who we are. And that is exactly what this brand new book from my guest today is doing. My guest is NYU Law professor Melissa Murray. Now, you might know Melissa from her appearances on MS Now as a legal scholar and analyst, but also as one of the co-hosts of the fantastic legal podcast, Strict Scrutiny. It is a weekly listen for me. It is a must-listen, frankly, because it informs how I understand the view of the legal world right now. Her brand new book, though, is The U.S. Constitution, a comprehensive and annotated guide for the modern reader. And what we talk about in our conversation is exactly that, how the modern reader can and should approach the U.S. Constitution, the lessons from history that are baked into it, and how they're not just stuck in the past, but how we can use them to inform our present, and not our present in the abstract, but the one that we're living through right now, and maybe how we can set ourselves and America up for more success. And seeing as how America turns 250 years old in just 2 weeks, I could not think of a better time to have this conversation, and I could not think of a better person to have this conversation with. It's Friday, June 19th, 2026. Welcome to Make It Make Sense. I'm Grant Hermes. Melissa, thank you so much for being here. I really appreciate it.
Thanks so much for having me.
Do I have to call you doctor now because of the new honorary doctor? Congratulations, by the way.
Thank you. It is not typical for lawyers to be called doctor. This new honorary doctorate is a big boon, but the only Dr. Murray I recognize is my dad. So I'm not Dr. Murray.
You don't make your kids call you Dr. Murray just a little bit, just for a little bit, like Dr.
Yeah,
Mom?
sometimes they make them call me Professor Murray if I'm feeling especially
They're in trouble.
Exercised.
Yeah.
Yes.
Well, I want to dive into this book because I think it's fantastic.
Thank you.
Just absolutely right up my wheelhouse. And one of those things that I was just like waiting for somebody smarter than me to write something like this. And I want to ask you first, how is the Constitution doing? How was it hanging on here?
So the Constitution's holding on. It was meant to hold on. I don't know that it was intended to withstand this many stressors all at the same time, right? So, when the framers sat down in the summer of 1787 to draft the Constitution, as I say, they were dealing with trauma. So they had the trauma of the colonial period on the one hand, and, the whole experience of having the British Parliament tax them relentlessly, and then the king sent a standing army into their cities. And then they had this additional trauma of trying to fight the Revolutionary War with a government that was basically held together with gum and friendship bracelets. So when they sit down in Philadelphia, they understand the assignment. They have to create a government that is strong enough to be efficient, to do things that governments do, like wage war, borrow money from foreign powers. But they are also deeply, deeply concerned that the government cannot be so powerful that it becomes tyrannical and runs roughshod over the people. So they are trying to strike this very delicate balance, and they do it in two specific ways. So, one is structural. They divide power between the federal government and the states, and then they divide the federal government's power between these three coordinate branches. And then they realize maybe structure alone will not guarantee the people's liberty. So they give the people rights. So the Bill of Rights is adopted in 1791, almost contemporaneous with the Constitution. And they recognize, though, what is the good of rights if the people act more like subjects than like citizens? So they recognize even in those early moments that they are not just crafting a new model of government, they are crafting a new model for the governed, right? So they need a governed people who understand the limits and who are prepared to enforce those limits on the government and who understand their rights and who are prepared to jealously defend them. And I think right now, we have a situation where one branch of government is being incredibly muscular, and that's not unprecedented. We have had very muscular, assertive, energetic presidents who have maybe pushed the bounds of Article 2 before. But I think what we haven't had is the other two branches either facilitating or midwifing those excesses, as the court is doing right now. And we've never had Congress kind of be off the field. Congress is kind of on the couch right now. So that is something I don't think the framers would have contemplated. They needed for the structure to work for each branch to check the other. That's the whole point of the structural divide. And then the other fix for preventing tyranny and ensuring democracy was a people who knew their rights, who knew the limits, and were prepared to call out the government when it went too far. And I don't know that we have that right now. And it's not the fault of our fellow citizens. We don't have rigorous civics education in our schools any longer. We have people who think the president can do a lot of things, which is not entirely true. And so, one of the reasons I wrote this book was we can figure out what the rules are. We can figure out what the state of play is, and we can step up and do the job that they intended for us to do.
I think one of the interesting things, too, about when we talk about the framers and how they were thinking is that there's this push me, pull you effect of how they were thinking, because they also, at their core, are elitists, and they're afraid of people, broadly speaking. I mean, you read things like some of the writings from Madison, certainly people like George Mason, and although they have some other amazing things in there in which they also believe that, that maybe having a house that gets elected every 2 years is better, even if it's more raucous or whatever, right? But that's built in there. There is no mention of slavery, not really, right, in the Constitution. I mean,
not explicitly, but it's everywhere.
But it's all over. Yes.
I mean, you're exactly right. These are very learned men. They have educations that are not typical for the time, and they are very distrustful of the common man, like the ordinary person. I think let's be fully honest here. I didn't write the Constitution. James Madison wrote quite a lot of it. I wrote the annotations, but I think James Madison would be shocked to find me as his collaborator and co-author in 2026. This is a man who had lots of virtues, but also lots of flaws. And this book is not a hagiography of the founders. It recognizes that when we talk about the founders, we actually should be talking about different groups of people because the Constitution has changed over time. And although many people fetishize the 1787 Constitution, it's undergone a lot of changes. And so there have been different groups of framers. We really only talk about one group, and that's to our detriment. But these original framers, they had some real hangups. And, one of their major hangups was the people. They wanted a people that was prepared to defend their rights, but they didn't always expect that the people would be equipped with either the knowledge or the capacity to do that. And so some of the structural interventions in the Constitution are intended to limit the role that the people might play. So as you say, the House of Representatives in Article 1 is elected every 2 years, and, it's much more raucous, it's more populous. The Senate, which they understand will be more like the House of Lords, they will have longer terms, 6-year terms. Those will be elected by the state legislatures or selected by the state legislatures, not the people. And it doesn't become this case that the Senate is popularly elected until the 17th Amendment is enacted and ratified. That doesn't happen until the Gilded Age, but it's because the people are fed up. They see the Senate being selected by state legislatures. They understand that this is a situation that is incredibly susceptible to corruption. State legislatures put in place people who have corporate ties, who do things that legislators want in Congress. I mean, if any of this sounds familiar to you, it's basically like putting lobbyists in
Right.
Congress. And so the people get mad, they agitate, and they get a constitutional amendment, and they change the Constitution.
I think that's one of the things that in this book, and when you talk about the Constitution on Strict Scrutiny and the other places that I've heard you talk about this book specifically as well, it's that the Constitution does move. It has this amoebic quality to it, and it does respond. And it feels like in the last, I would say, maybe half century or so, I think maybe we get some, but really I think post 25th Amendment, it feels sclerotic in a way.
Yeah. Well, amoebic is such a great term for it. Like wonderfully evocative language to think about is sort of like oozing around.
Yeah.
And it does. There have been a lot of moments of constitutional change, often spurred by a moment of incredible rupture and trauma. So, there's the Revolutionary War and the experience of colonialism that prompts the original Constitution. There's a major shift in the mid-18th century with the Civil War, and we get the Reconstruction Amendments.
Right.
The Gilded Age, which I don't think we think of as a moment of trauma, but it certainly is for ordinary people who are not wealthy, and it is a time of unbelievable wealth inequality. I mean, if any of this sounds familiar, it should. Like, we've lived in the age of oligarchs before, and what prompted changes were constitutional amendments that sought to limit the impact of wealth in the political process and in politics. We also have these other moments of rupture, the assassination of John F. Kennedy, the civil rights movement that prompt other constitutional amendments in the 20th century, in the 1950s, 1960s. Birch Bayh, who was a senator from Indiana, is the most unsung hero of constitutional making in the history of this country because he almost single-handedly shepherds the modern constitutional amendments through to fruition. And he gets very close to amending the Constitution to get rid of the Electoral College. He just misses by just a few votes. I mean, he's very, very close. But you're exactly right. Things slow down in the 1980s. We haven't had a constitutional amendment since the 27th Amendment, which was ratified in 1992. And I will say, spoiler alert, that was the work of a college student named Greg Watson. An amazing story of ordinary people doing extraordinary things. But, I think part of the reason why it's been a little sclerotic is that we only have two methods of constitutional change in Article 5. One originates in Congress. Right now, Congress is incredibly polarized, riven with partisanship. Under those circumstances, you're not likely to get the kind of supermajority votes that you would need to get a constitutional amendment through Congress and then out to the state legislatures.
Right.
We also have incredible distortion in the electorate in state legislatures because of partisan gerrymandering. That also makes it difficult. The other method of constitutional change, in which a constitutional convention is initiated at the state level, has never actually succeeded, although I will say there are many red states that are deeply, deeply interested in calling a constitutional convention. And given how distorted and skewed some of these state legislatures are because of partisan gerrymandering, one of the reasons why they're so hot to trot to do this is because they think they have the numbers to really just take a hatchet to the existing Constitution and change it up entirely. So there may be constitutional change in the offing, and maybe not as sclerotic as might be the case through other means. And maybe we might want a little sclerosis given some of the changes they'd like to put in place.
Sure. I think of it too as from the 80s forward, this sort of emergence of originalism, textualism from the Thalia Law School thing. We don't have to get into that here necessarily, but I think of it as sort of this creeping brittle bone disease that comes out of this very specific vision of how the Constitution should be viewed. And for my money, the way that we should think about the Constitution is that it actually starts in Reconstruction. The framers and founders are great, but those are roadmaps to get us into what is a brand new America after the Civil War.
Yeah, I think that's exactly right. Reconstruction and the 13th, 14th, and 15th Amendments, collectively known as the Reconstruction Amendments, are a
Yeah.
watershed moment that are meant to completely renegotiate the constitutional order and shift the balance of power between the federal government and the states,
Mhm.
and between the federal government, the states, and the people. It is interesting that we fetishize the original founding and the 1787 Constitution, and we give short shrift to the Reconstruction Amendments.
Yeah.
And maybe that is because the Reconstruction Amendments are the foundation of a multiracial democracy.
Yeah.
We had democracy before, but not a multiracial, multi-faith democracy of the sort we are trying to maintain now. The basis for that incredible change in the electorate and in the populace is the Reconstruction Amendments and the legislation that it engenders. Ask yourself why so many people are hot to trot to limit the teaching of Reconstruction. Like, if you're going to teach slavery, you're going to eventually teach Reconstruction. So when they want you to stop talking about slavery, stop talking about the civil rights movement, you're inevitably going to stop talking about this moment of constitutional change. Query why we know James Madison and George Mason and Patrick Henry and George Washington, but we don't know Lyman Trumbull or
Yeah.
John Bingham or Frederick Douglass or any
Yeah.
of these people who were pivotal to the Reconstruction Amendments. That's by design. And if we want to truly reconcile our Constitution with what it could be, what it's supposed to be, with what it is, I think we have to grapple with that history and make that history more widely known.
You said earlier that this thing, the annotations in your book here are meant to be, I guess, sort of an owner's manual is the way that you were kind of describing it in a way. And I toggle back and forth on how I think about the Constitution as an owner's manual for the country, or as more of like the take care instructions you get when you like buy a bouquet of flowers from the grocery store, right? Right? Like,
Yes.
is it like, and I don't actually know. Is it a direct way of like, this is how this is supposed to run, or should we think of this more as like a suggestion, or is it
Maybe
both? I guess.
Maybe a little of both. I
Yeah.
mean, it could be an owner's manual if you imagine it as fixed and not going anywhere. At least, like, these are the rules of the road. These are,
Mhm.
the way you might operate this particular vehicle. If you think about it as that pouch of weird powder that you drop into your flowers, it is also a means, I think, of preservation for, longer maybe than this document might have endured on its own.
Mm.
And there are lots of different ways to think about it, but I think the common thread that unites both of those visions is that it really depends on the people. I mean, the idea of a government, a constitutional republic, or a Republican democracy, and I say small r
Right.
Republican democracy or democratic republic, if you will, is that the people are there. Maybe they are
Mm.
not directly represented. Like, I don't need Mike Lee dropping into my DMs to remind me that we are not a true democracy. Like, I get it. But the people are still at the core of this enterprise, and we can't lose sight of that. And I think we have ceded too much power to the folks in Washington and assume that they know this
Mm.
document better than we do. Like, FYI, I don't think many of these guys know this
Yeah.
document, certainly not the ins and outs. And if they do know it, they're not being faithful to it right now.
Yeah, I think that's like case in point. I mean, for starters, Mike Lee sliding into my DMs, like shiver down my spine. But case in point, what you just said is that I think built into how the framers are thinking about the separation of powers, because I want you to explain a little bit about how you understand
Mhm.
separation of powers in this book, uh, is that they also kind of leaned on the worst wills of men, basically,
Yeah.
like
Yeah.
your capital M, humankind or whatever, and assumed that people in power would clamor to hold on to power, and that was going to
Yeah.
be the fight between the executive branch
Yeah.
and the legislative and the judiciary, and we're not
Yeah.
seeing that right now. And I think that's this weird disconnect.
Like, we're not seeing the fight, or we're not seeing people
We're
desperate
not
to hold on to
we're
power.
not seeing Mike Johnson is not desperate to hold
Yeah.
on to the power that the speaker has, right? No Republican in the House right now, most Republicans in the Senate are not desperate to be like, we have robust power under the Constitution against the executive branch. That is, they're antagonistic to each other by design.
Right. I mean, you're exactly right. So the framers imagine that this is always going to be a contest, mostly between the
Yes.
president and Congress.
Mhm.
Again, the judiciary is really kind of an afterthought
Yeah.
for them. And, until John Marshall comes along, rests judicial review for the courts, and then runs back to his office to stroke a hairless cat for an hour. His major triumph for the courts. But yes, they imagine like the tension is going to be between this fast moving, nimble executive and this slow moving, deliberative, multi
Yeah.
member body that is Congress. And that's going to be the tension. And Congress is going to jealously guard its prerogatives. The president is going to push, but Congress will always push back. I
Mhm.
think what James Madison and his band of merry
Mm.
men did not contemplate was the rise of political parties in the way that they are here. I mean, they
Me.
understood that there would be factions, and Madison writes extensively about the threat of factionalism, but I don't think they imagined it would take root to the degree that it has, and that the country would be almost neatly divided
Yeah.
between one side and the other, and that this would come to shape political identity more so than allegiance to your particular branch. And so it's not that Mike Johnson isn't desperate to hold on to power, but it's not for Congress. It's for the
Right.
Republican Party. And I don't think they envisioned that
Yeah.
as the kind of fulcrum around which this push and pull would be animated.
Yeah. One of the things too that I really enjoyed the way that you write about this and have spoken about this in your book as well when you talked about it is your annotations to the 14th Amendment and birthright citizenship, and that we're not doing a very good job of understanding it right
Yeah.
now. Can you walk me
Yeah.
through
Sure,
what
sure.
that is? Because that right now that is on the line, right? I mean, we are
Yeah.
going to get a ruling from the Supreme Court any day now, I suppose.
Probably on the very last day of term if passed
Yeah,
as
President
prologue.
holds, right? Yeah, because they want to wait for the news dumps so that Alito
Yeah,
can
and then
pull
and
away.
to
Yeah,
be very clear, I think one of the reasons why they're waiting is that this will be a defeat for the president. And
you
when
think
the
so?
executive order is invalidated, and I think it will be, I don't think it will be unanimous. That will be a travesty, and I'll say why in a moment. But it will be a loss for the president. It will be framed as a win for the court. This court standing up to the
Sure.
president. When that gets said, I want every listener on your program to be like, absolutely not. This is not a win for the court. This is not the court defending the Constitution. Because if you can read Section 1 of the 14th Amendment, you knew what to do. You understood the assignment because it's really straightforward. It basically says if you're born in this country and subject to the jurisdiction therein, you are a citizen of this country. It was a common law default that existed when we became a country. The only time it was disrupted was in 1857 with Dred Scott versus Sanford, where the Supreme Court, in a fit of what can only be understood as abject racism,
Mhm.
decided that those who were descended from African slaves could never be citizens, regardless of where they were born. That is the departure from the common law rule that the 14th Amendment's Section 1 was intended to repudiate. It was
Mhm.
intended to restore the common law default. And the common law
Yeah.
default was a rule of jus soli citizenship. If you're born here, you're a citizen of this country. Immigrant, Black, whatever. If you're born here, that's the common law default. That's what Section 1 is restoring. Anyone on the court who can read knew this.
Mhm.
And this is the same Constitution that we had last year when a question around birthright citizenship in this executive order came up before the court. It was a jurisdictional question about whether or not federal district courts could issue nationwide injunctions stopping this administration from rescinding
Mhm.
the Section 1 of the 14th Amendment. And this court answered that question. It limited the use of the nationwide injunction for federal district courts, made it much harder for federal district courts to stop the administration. And they left open the substantive question of what does the 14th Amendment's Section 1 actually mean? And they let this question of birthright citizenship, an asked and answered question in the Constitution, they let it percolate and they let it fester, and they made life unsettled for millions of people in this country. And so when they finally come around to answering a question that anyone who is literate could answer, do not give them the benefit of your grace. Like, it was literally the least they could do, and they could have done it a year ago.
Yeah. And naturally, this moves right into the voting rights amendments, right?
Yes.
This is the 15th, the 19th, and the 26th amendments, and
Yeah.
uh,
The 14th
again,
to some degree.
and
Yeah.
the 14th to some degree as well, right? And again,
Yeah.
we're not doing a very good job of those things, and I love the way that you annotate those in this book, because that part of it feels like, or at least the way that when you've talked about this as well, like it feels the most tangible
Yeah.
to me, because
Yeah.
maybe they feel more modern in a way as well, even though they're kind of not. The 26th certainly is, but like it feels way more usable, I think, to people. And I think we could talk about that as an idea of the Constitution itself doesn't feel usable to people.
Well,
Yeah.
so I will say the thing that's so interesting about the Reconstruction Amendments, all of them, the 13th, 14th, and the 15th,
Yeah.
the 19th Amendment, which is modeled on the 15th Amendment, and the 26th Amendment, which is modeled on the 19th and the 15th. The 19th is about gender. The 26th is about age. The 15th is about race. All of them pertain to the vote and basically say that the state may not discriminate on the basis of race, gender, or age in administering the right to vote. Each of those amendments, the 13th, 14th, 15th, 19th, and 26th, all have an enforcement clause. So there is a clause in each of those amendments that enables Congress to pass legislation to bring into fruition the spirit, the aims of those specific amendments. And what the Supreme Court has effectively done in Louisiana versus Kelly, this was the recent case that hobbled, maybe gutted entirely, the Voting Rights Act, is said that Congress doesn't have the authority to do what it was doing with the Voting Rights Act, which was making it hard for states to draw districts in ways that diluted the electoral power of minorities. Said that Congress, when Congress passes laws to ensure that certain voters aren't suppressed or limited in their right to vote, like, there are certain rules that they have to follow. They're basically stripping Congress of power. Right? They're interpreting these laws in ways that narrow them completely and make it just impossible for the spirit of these amendments to be actualized. And the court knows that. They know what they are doing. They know that they have been limiting the power of Congress to do lots of things, mostly civil rights legislation, since at least the 1990s. This has been an ongoing project of legal conservatism, and this moment where they've effectively hobbled this landmark legislation written in the blood of protesters and passed at the height of the civil rights movement, they've hobbled it. And this was the apotheosis of their assault on civil rights. And it's going to have lasting consequences that we will live with for certainly the remainder of my life.
I mean, there will be a lot written and said about the legacy of John Roberts, but he wants this to be his legacy. This has been his life's mission, to hobble the VRA in this way. And I think undermine these
but he doesn't want to be upfront about it. Like, the thing about John Roberts that you've got to understand is, like, this is a guy who wants to be America's biggest institutionalist. I mean, he says at his confirmation, just calling balls and strikes. It's like the dumbest thing anyone's ever said, because it's true. I guess you could think of a judge that way, but I mean, that's basically like judging by macro, like shift F1, it's a strike, shift F2, it's a ball. Judging is delicate, sensitive work because not everything is straightforward. And he knows that. He's not a dumb guy. He knows that. He's literally trying to fool you into thinking he's just like, I'm just out here, I'm just call him as I see him. There's judgment there, and he's making judgments. The New York Times reporting by Adam Liptak and Jodi Kantor about the rise of the modern shadow docket shows John Roberts, noted institutionalist, acting like a political operator. Like, angry at the Obama administration, angry at the EPA, and literally using this procedural docket that is supposed to be about case management to affect partisan ends. John Roberts is not an institutionalist. I say this over and over again on Strict Scrutiny. This is the man that has written 3 decisions that are absolutely corrosive to democracy. He wrote 2013 Shelby County versus Holder, which demolished the Voting Rights Act's pre-clearance regime. He wrote 2019's Rucho versus Common Cause, which effectively blessed partisan gerrymandering by saying that federal courts had no role to play in enforcing or stopping partisan gerrymandering. And he wrote Trump versus the United States, which essentially gave the president a blank check and immunity to do whatever he wants because basically almost everything falls into the realm of an official act or adjacent to an official act and therefore
Right.
subject to this broad grant of immunity. He's been absolutely corrosive to democracy. He is not an institutionalist. The Voting Rights Act is his pet project. He does not want this on his epitaph. He wants that balls and strikes nonsense on his epitaph. Do not be fooled. This man hobbled the Voting Rights Act. He was put on the court to do it, and he did it.
I mean, there's photo evidence of him shaking hands with Ronald Reagan as like a DOJ staffer, right? And he got brought into that White House to dismantle, to find ways to undermine and dismantle the VRA. That's how he got his start and why he is where
and he was
now.
assisted by his very able henchman Samuel Alito, who also did it.
Yeah, long-time listener, no-time caller, Samuel Alito.
Yes.
Right.
You know how every social media platform is basically engineered to make you angry and keep you scrolling? That's not an accident. Outrage performs better than nuance, so the algorithm feeds you outrage. I see it every day as someone making news content for a living. The loudest, most biased takes get the reach. The careful, fact-driven stuff like I do my best to bring you here gets buried. That's why I joined Say So. It's a brand new news app just launched, built by a group of former journalists and engineers who asked, what if we build news from scratch for people who actually want to be informed instead of people who just want to keep scrolling? No algorithm optimizing for outrage, no AI slop, just vetted creators delivering fact-driven coverage, curated, so you can know what's going on in 5 minutes and then get on with your day. If you're the kind of person who is intentional about your sleep, your workouts, your work, what you eat, but your news diet is just whatever your feed throws at you, this is for you. The same energy finally applied to how you stay informed. I'm one of the first creators on Say So, and my favorite feature is that I can link my sources right in the video. That way, you know how I'm telling you the truth. And if you sign up now, you'll be one of the first users to join. You can download Say So. The link is in the show notes and the description. Go check it out and be as smart as you know you are. All right, let's get back to the show.
I want to ask you too about some changes. Are there ways that we can improve the Constitution to both strengthen it and our sovereignty as people here? Because that's also one of the driving ideas in your annotations, is that this country is the power of the government is derived from the people. And that's so clear and so part of the basis of this thing, but it gets muddled in politics in the way that these things are now. But how do we strengthen that without it becoming sort of this weird libertarian thing that ends up, that would be up Mike Lee's alley, right? Like whatever, right? How do we get away from that into this other thing where this is about civic infrastructure and not this other thing?
So, it is very hard to amend the Constitution. So let's just start there. And that's by design. I mean, I think the point of the framers was that you can't change these rules of the road willy-nilly. Like if these are commitments that you felt were important enough to enshrine in writing, then they can't be commitments that you just change because things are inconvenient. And, there are times when I'm like, yeah, that makes a lot of sense. Can you imagine coming out of 9/11 and just the incredible fear and concern around public safety and anti-terrorism that we as a country experience? There would have been such appetite to change fundamental parts of the Constitution, maybe to limit First Amendment freedoms for certain groups or for certain conduct. And I'm glad we had a Constitution that just makes it hard to do that, because I'm sure there would have been people itching to change things because they were afraid or, they were genuinely concerned about the threat of terrorism. But if these commitments are our commitments, they can't be itinerant and we can't be selective about how we defend them. So for that reason, it's hard to change the Constitution. That doesn't mean it's impossible. It is harder still in this moment because of political partisanship and distortion in the electorate. It means, though, that the people have to work double time to kind of make up for those distortions and to compensate for and counteract the partisanship that literally are the headwinds to this kind of constitutional change. So, you can do a lot of what you would like in government through statutes. If you want better statutes, get a better Congress. Right. So, I mean, And I get it. That's hard given the gerrymandering, the way districts are drawn. You literally have to double the electorate in order to counteract the structural distortions that they have built into the system. It's not impossible, though. I mean, we saw in 2024, there's a whole section of the electorate that didn't come out. So, I mean, there are people that we can turn out and there are new voters that we can get energized. And we have to do that. They are working overtime to make us disaffected, to make us disengaged. When people turn out to vote and then nothing happens, they have no incentive to go vote again. And that's the whole point. Like if, you got everyone excited and then nothing happened, why would they be excited? We have to keep pushing. So there is that. There's also, I think, the realization that even if you get a new Congress, a great Congress, a Congress that does the things you want, and you pass great laws that address the problems you have, this is going to be challenged and go up to the Supreme Court. We have a Congress, and we get the Congress that we want. This is a Congress that can do court reform, and court reform should be on the table for every voter. We have a Supreme Court that's absolutely out of control. It is completely uncalibrated, largely through partisan machinations. Like we have a 6-3 conservative supermajority. It's not supposed to be a conservative supermajority. If Barack Obama had gotten the pick that he was entitled to, Neil Gorsuch wouldn't be on this court. This would be 5-4, not 6-3. Now that it's 6-3, they actually could lose a person. They could have someone like, I don't know if I'm a terrible person today, drop off, and they could still do what they want. 5-4 makes it harder. If we have a Democratic president, there may be more opportunities to identify people for the court who are more in keeping with where the electorate is. Like Justice Thomas, Justice Alito are septuagenarians. The Chief Justice is getting up there. They're going to either retire or not be on the court for much longer. I mean, just real talk. I mean, this is not wish casting or anything. It's just life. If you have a Democratic president in position during those periods, you have an opportunity to change the court. Because realistically, judicial interpretation is one way that constitutional change actually does get made. Maybe even the principal way that constitutional change has been made during our lifetime. So, we can do this through Article 5 and, just turning out the electorate. We can do this through Congress, recognizing that what Congress does may be challenged and go to the court. But I think if we want lasting change, we've got to think about what this court is doing and how we can counteract it. And some of that might be done through Congress, jurisdiction stripping, taking away the court's power to hear certain cases. Some of it could be done through adding more justices to the court, maybe doing term limits. Some say that requires a constitutional amendment. Others say that can just be done statutorily. Either way, everything should be on the table.
Yeah, and I want to encourage listeners to go back to last week's conversation with Barb McQuaid, where she talks about the fix and her new book, which is also excellent. And we talk a lot about fixes to the Supreme Court and the judicial system, and she brings up ideas of senior Supreme Court justices and maybe certain terms for Supreme Court justices that would still match the Constitution, but could just rotate them through and cycle them, which I think is a really interesting idea. When we think about changes to the Constitution too, I also think about this idea of, again, the accessibility for people. And so when you were writing this, did you have that in mind, that this document should be as a thing to argue and counter, or as just a way for people to walk around with this knowledge in their heads? Because in writing things you've got from civics class, that's this back and forth that I go through too, is that is this something that you should be armed with and ready to have at arms, versus just something you should have and feel? I think it's a little bit of both, but where do you come down on that?
So, the Constitution, when it's sort of written out and printed, is probably 12 pages, right? My husband is like, if it's 12 pages, why is this book 300? It's the annotations.
So because I have a publisher, things. That's why. Yeah.
Right. Well, and the annotations. But it's spare. I mean, this is the reason why you need judicial interpretation, and John Roberts calling balls and strikes is just, reductive.
Right.
Some of this stuff is just very spare and open-textured, broad language that requires interpretation. And that was by design. John Marshall, famous Chief Justice, early court era, says in McCulloch versus Maryland, they didn't write everything down. If they did, this would look more like, sorry, dog.
You're good.
They didn't write all of this down because if they did, it would look more like a code and nobody would read it. Like nobody's going to sit down and like, I'd love to read 18 USC section 45. Like no one does that.
Barn
But the
burner.
Constitution, it's not a barn burner. The Constitution was supposed to be a barn burner, though. Like they wanted the people to read it. They wanted it to be accessible. They wanted it to be debated and talked about. And in order to do that, it had to be spare. It had to be short. It had to be accessible. And that's the spirit in which it was written. And it's also the spirit in which I do the annotations. Like there's not a lot of legal jargon. I try to explain everything. I mean, honestly, the target audience for this book is a very literate high school student or a very, very smart sixth grader. Anyone can read this. Like my mom, not a lawyer, she would have loved this book. She would have loved reading it and learning from it. And, I tell stories in it because I think that's how people come to embody the document. Like when they see other people and the history of how other people embodied this document as well.
Last couple of things here. If you could wave a wand and add an amendment, what would it be to this?
Electoral college reform. Just get rid of it.
Not gerrymandering? Okay.
Electoral college would help with the gerrymandering, sure. I think, and vice versa. I mean, there's so many places to start. Electoral college, because we've gotten so close, and I think there is broad appetite for that. I think people genuinely wonder why Montana has so much political power given the relative size of its populace. Like, let's just do this in a population-based way, which is not to say it means that progressive people will always be elected. It won't. There have been times when Republican presidents have won the popular vote, but I do think it would just feel more fair and it would limit some of the structural distortions that occur on a state-by-state basis that have been built into the Constitution. I would also say DC statehood. DC is a big player in this book and in the amendments. There's a lot of discussion of the effort to cite the Capitol in DC, the effort later to provide DC with some measure of representation, and it's very thin representation. So DC has a non-voting delegate in Congress. I say DC statehood, get them an actual delegate in the Constitution, get them an actual voting member of Congress to represent them. And then in addition to allowing them to participate in the presidential election, just formally make DC a state. And when you're done with that, maybe go to Puerto Rico.
Yeah. Well, Melissa Murray, thank you so much for coming on the show. I think this is required reading for anybody who is looking to, have some kind of hope for the 250th birthday of America. So thank you so much. This was such a pleasure.
Thank you. I concur. Required reading.
I want to thank Melissa for coming on the show again. You can find links to her brand new book, The U.S. Constitution, A Comprehensive and Annotated Guide for the Modern Reader, in the show notes for this episode. And that is it for today's episode. Please rate and review the show wherever you get your podcasts. Like and subscribe if you are a watcher on YouTube. Sign up for the Make It Make Sense Substack. And as always, share the show on social media. You can tag me at Grant Hermes on Twitter, Blue Sky, and the Say So News app, and at Grant_Hermes on everything else. Thank you so much for listening today. I'm Grant Hermes, and I'll talk to you next time.